Welcome to The Voter's Voice, where we lay out the bills and you decide if they make sense.
Today we're tackling a really specific piece of California legislation, Assembly Bill 1127. It's aimed at banning what the state calls machine gun convertible pistols. We've got the source material on the legal strategy here, and our mission really is to unpack what this law actually targets. And crucially, look at the legal fight it's facing under the Supreme Court's Bruen standard for the Second Amendment. Right, so AB 1127, signed back in October 2025. It's set to kick in July 1st, 2026. It's a very targeted ban on selling a certain kind of semi-automatic pistol. And the interesting thing is, it's not banning the gun for being automatic. It's banning it because of one tiny internal part, the cruciform trigger bar. The state's argument is this little piece makes the pistol readily convertible with an already illegal device. We're talking about the mechanism used in, well, the most popular handguns in the country.
Exactly. And that's the core conflict, isn't it? The law goes after a perfectly legal, very common firearm. And it does this based on the potential for it to be modified by something, the Glock switch or pistol converter, that's already completely illegal to possess. The analysis we're looking at finds this is basically an unconstitutional restriction. It just doesn't meet that strict historical test from Bruen.
Okay, let's break down the law itself first. The language seems incredibly precise. What exactly defines a machine gun convertible pistol, or MCP, according to this bill? What's this technical feature?
Yeah, it's very specific. An MCP is defined as a semi-auto pistol that has this particular internal part, the cruciform trigger bar. It's shaped like a T, basically, and it's key to how the pistol functions semi-automatically. But its shape is also what allows one of these illegal converter devices to just slot onto the back of the slide. That device then bypasses the gun's normal mechanics and makes it fire automatically. So the law says, starting next July, licensed dealers, FFLs, they can't sell or transfer these MCPs anymore.
And the source material highlights just how surgical this is. It specifically carves out other types of striker-fired pistols, ones that don't have that T-shaped bar. It really seems laser-focused on the platform using this design.
Absolutely. And that specificity, well, it actually strengthens the legal challenge. It shows the state isn't banning a whole class of weapons because they're inherently dangerous, but targeting a common product based on, one single internal component's design.
What really jumps out at me is how this interacts with California's unsafe handgun roster, the UHR. It looks like they're not just banning the MCP outright, but using the threat of the ban as a kind of leverage.
Oh, it's absolutely a form of regulatory coercion, deeply so. There's a specific provision in AB 1127 that offers manufacturers a way back onto the roster for some of their pistols. But, and this is the key part, only if they redesign the gun to remove the feature that makes it an MCP. So change the trigger bar. Now, why is that such a big deal? Because making that change lets them sidestep other really tough UHR rules, particularly microstamping.
And microstamping. That's effectively blocked almost all new handgun models from being sold in California for years, right?
That's right. The source materials really emphasize this. Microstamping is so technically challenging, maybe even impossible for some designs, that it acts like a de facto ban on new handguns coming to market. So by offering this waiver, get rid of the trigger bar we don't like, and you don't have to do microstamping, the state is basically holding their ability to sell any version of their popular pistols hostage. It kind of lays bare the intent. It's about forcing a redesign of a specific, very popular product. It's product control.
Okay, let's shift gears to the policy side. The stated goal is public safety, getting illegal machine guns off the street. But the sources argue this law doesn't actually hit the real criminal threat, mainly because the conversion part itself is already illegal.
That's the central policy critique, yes, the pistol converter device. It's already defined as an illegal machine gun or machine gun part under both federal and state law. Just possessing one of those switches is a serious felony right now. So this new law, AB 1127, expanding the definition of machine gun, functionally, it doesn't really add much in terms of penalties for the person caught with the illegal switch. It's redundant from that perspective.
So if the switch is illegal anyway, why target the legal sale of the pistol itself, especially through dealers who are already heavily regulated?
Right. And if you look at the bigger picture, the data tells a story. Law enforcement saw this huge spike, 570%? In recovered converted guns between 2017 and 2021. It's a serious problem, no doubt. But the sources are clear. This flood is coming from illegal channels. We're talking about conversion devices made cheaply, sometimes with like $100 3D printers or trafficked internationally. AB 1127 targets the legal sales, the FFLs operating within the rules, instead of putting resources into stopping the illegal manufacture and trafficking of the conversion devices themselves. It seems misdirected.
But couldn't the state argue they're just trying to stop new, potentially convertible guns from entering the market, even if they can't easily control the illegal switches or existing guns? Which brings us, I guess, to the biggest contradiction mentioned in the sources: the exemptions in the law.
Ah, yes, that's the point that really undermines the whole public safety argument from a legal standpoint. Okay, so the ban doesn't apply to sales to law enforcement or the military, which is standard, but, and this is crucial, it explicitly exempts private party transfers, PPTs, that happen through an FFL.
Can you spell out what that means for the listener? Why is that exemption so significant?
It means that even though dealer A can't sell a brand new MCP off their shelf, two private citizens, B and C, can walk into that same dealer A's shop and legally transfer a used MCP between themselves, with the dealer just handling the paperwork. So if these MCPs are supposedly so abnormally dangerous that they have to be banned from commercial sale, why allow them to keep being transferred freely between private individuals? It completely cuts the legs out from under the public safety rationale. It strongly suggests the ban is pretextual. It's not really about the danger, it's about restricting the lawful market.
Okay, so if the policy arguments seem shaky, the real test is the Constitution. Let's talk about the main legal challenge: the Second Amendment under Bruen.
Absolutely. And Bruen sets up a two-step test, essentially. Step 1, does the regulation affect conduct protected by the Second Amendment? Specifically, does it regulate arms typically possessed by law-abiding citizens for lawful purposes? Well, the guns targeted here, Glocks, similar striker-fired pistols, are undeniably in common use. They are protected arms under the Heller decision. Millions are owned for self-defense. That immediately puts a very heavy burden on the state for Step 2.
Right. So for Step 2, the state has to show this ban aligns with the nation's historical tradition of firearm regulation. What makes finding a historical parallel and analog so tough for this specific law?
This is where the state's case really seems to fall apart, according to the analysis. Step 2, finding that historical tradition. The state needs to find laws from, say, the 18th or 19th century that banned a common protected firearm just because of an internal design feature, and its theoretical potential to be modified by an illegal third-party part that didn't even exist back then. History just doesn't offer that.
So what kinds of historical gun laws do sometimes pass muster under Bruen?
Well, the historical laws that courts often look at involve things like restricting carrying guns in specific sensitive places, think courts, legislative buildings, or maybe bans on weapons that were truly dangerous and unusual at the time, and definitely not in common use for self-defense. Some early machine gun laws, maybe some bans on sawed-off shotguns, might fit that category depending on the context, but there's just no tradition of laws saying, okay, this common pistol is banned because this one little internal piece, the trigger bar, has a certain shape that might someday allow an illegal future gadget to make it automatic.
That gap between old laws regulating carry or truly unusual weapons and this modern component-specific ban on a common gun, it seems like a huge hurdle for the state.
It really does. They can't point to a historical tradition of banning a legal gun because of a hypothetical modification using an illegal part that wasn't even conceived of back then. This kind of surgical ban based on internal mechanics is a modern regulatory invention. And under Bruen, that means it likely fails the historical test.
Now, looking at the planned lawsuit, the arguments aren't just about the Second Amendment. The sources mention a 14th Amendment challenge, too, about due process and vagueness.
That's right, the substantive due process claim. It focuses on vagueness. The law uses technical terms like cruciform trigger bar. Okay, maybe that's definable. But then it uses more subjective phrases like the gun being readily converted by hand or with common household tools. What exactly does readily mean? What counts as a common household tool in this context? Since breaking this law means serious criminal penalties for dealers, maybe even losing their license, they need crystal clear notice of exactly which guns are illegal to sell. If the language is too vague, they don't have that adequate notice, and that's a potential violation of the due process clause.
And with that July 1st, 2026 date looming, the immediate legal goal has to be stopping the law before it even starts, right?
Absolutely. A preliminary injunction is the first and most critical step. The argument is that violating a fundamental constitutional right here, the right to acquire common arms for self-defense, causes irreparable harm per se. You can't easily fix that harm later with money damages. Allowing the ban to take effect, even for a short time, infringes on citizens' rights and puts FFLs in immediate legal jeopardy. Given the weakness of the state's case under Bruen, the sources suggest the chances of getting that injunction are quite high.
Beyond just fighting this specific law, the analysis also points towards more proactive strategy for the future. What are manufacturers or gun rights groups suggesting should be done instead of these kinds of bans?
Well, part of the broader strategy is pushing for alternative legislation, model laws perhaps, that focus resources where the actual problem is, stopping the illegal making and trafficking of the conversion devices themselves, and cracking down on the sharing of digital blueprints online that allow people to 3D print these things. It's about shifting the legislative focus away from the legal, regulated gun market and onto the actual source of the illegal machine guns, the criminal tech and trafficking networks.
The sources also mentioned that manufacturers might think about voluntary design changes. Why would they do that if they expect the law to be struck down anyway?
It's partly a political calculation, a way to sort of preempt future similar laws.
Right.
If manufacturers make minor tweaks to the design changes that don't affect how the gun works normally, but do physically block a converter from being installed, and they do this without adopting things like microstamping, then they can argue they've engineered away the supposed deadly design flaw. It removes the political justification, the pretext that lawmakers are using to target their products. It makes future attacks harder to sell to the public.
Okay, so to wrap up this deep dive, the argument against AB 1127 is essentially that it's not a real crime-fighting tool, because the dangerous part, the converter, is already illegal. Instead, it's seen as a way to effectively ban the sale of some of the most common handguns people use for self-defense. And the legal challenge looks strong, primarily because the state likely can't provide the historical proof required by Bruen to justify banning a common firearm based on just one internal component's design.
Which leaves us with a pretty important question for you, the listener, to think about. If the real threat, these illegal conversion devices, are being made easily with 3D printers and coming in from overseas, and banning legal gun sales through licensed dealers does absolutely nothing to stop that illegal supply chain, then why do lawmakers keep focusing on banning common, legally sold products instead of putting serious resources into shutting down the tech trafficking networks where the actual danger seems to be coming from?
Hope you enjoyed this episode. Tune in again to make sense out of all the bills.